day.
Your Honor, now that Mr. Coons has begun testifying, I expect that I can expect from the defense the basis for the testimony regarding looking at Rule 705 for the facts and data that was relied upon.
Was that not part of his report?
Well, Your Honor, that as we discussed at that hearing on the 12th, I was believed,
Yes.
not everything was disclosed to the state, and now that the testimony has begun, it's time to hand it over.
Mr. Sand, one of you?
Yes, Your Honor. Kind of switching gears here. So if I can look at, I did print out the rule in anticipation of this.
You can have a seat.
Thank you.
Thank you very much. Again, it's Rule 707, Mr.
705, Your Honor.
Sorry.
Yeah, Your Honor, it specifically says the expert may be required to disclose those facts and data on cross-examination. We haven't begun that.
Well, I'm requesting that the court require that, Your Honor.
Prior to cross-examination?
Yes, Your Honor.
Your Honor, if we may have a moment to pull the order from the court.
Sorry?
We're pulling up the order from the court, Your Honor. Is that all right?
Sure.
Thank you. Looking at index 347, which is the order in this case, says that we were in compliance with the rules of evidence 702, 703, or 705. So it doesn't specifically say when we need to disclose it, but we're in compliance with 705. We would request that Rule 705 is followed, which states that the expert may be required. I'm not saying that I'm going to waive any objection. But we haven't even gotten to the point where they can request it. May be required to disclose those facts or data on cross-examination.
Point out that I did cross-examine the witness briefly during when I voir dired the witness as well.
Yeah, that was not, I mean, that was voir dire, not pertinent testimony regarding his investigation.
It was the basis for him being an expert.
All right. Yeah, I don't have one here. Mr. Nelson, give me your rule book, please.
Sure. Here's what I have, Your Honor.
Thank you very much.
I was away from the microphone, just for the record, I provided the court with the rule book and pointed to where 705 was.
Thank you, Mr. Nelson. I believe that's what I required of you.
It is, Your Honor, but I was away from the microphone, and Colette doesn't like it when we're away from the microphones.
Okay, once again, Mr. Nelson, I believe you are correct. However, I do believe you are premature. I realize I gave you some leeway with regard to voir dire, with the witness with regard to his expertise. However, I think under Rule 705 that cross-examination is required for that information. So I'm going to deny your request at this time. However, if we get to that point for cross-examination, then that information should be available. So does that make sense, Mr. Sand?
Available as far as the identification or the actual materials, Your Honor?
I think it requires the both. Let me make sure I'm clear on that again. The expert may be required to disclose those facts or data on cross-examination. So his facts and data that he used to come to his opinions, that's the point of this. Unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data. The expert may be required to disclose those facts or data on cross-examination. So again, when he gives his opinions, he's entitled to give them based upon being an expert. He doesn't have to disclose what facts he bases his opinion on unless he's cross-examined to those opinions. And once he's done, then he's required to give them, either by way of testimony or by way of documentation.
Yes, Your Honor. I believe the one thing that did come up that he testified outside of everything that the state already has was he identified that there was an interview done by a private investigator of Brenda Glintz. He identified that already on the record.
Correct.
So I'm not sure. I mean, he's identified it.
Well, again, the way it works, Mr. Sand, at least this is my understanding, being a novice in this occasion, is that when Mr. Nelson cross-examines him and he wants to go into his opinions, that at that point, when he asks him about those opinions again, he can ask him specifically the information what he used to come to his conclusions.
Sure.
And that has to be available. If it's already available, if it's information that he got from the state or from the documentation that he got from the state originally, that would be fine. If he got it from some other source, he will be required to disclose that.
Now,
That's my understanding.
my question, Your Honor, and I'm not trying to hide the ball, is disclose or produce?
Well, I believe it says disclose, is the way I read it.
I mean,
Required to disclose, this is exactly what the wording is, those facts or data on cross-examination. So he has to disclose it, where he got it, what he based it on. So that's my understanding.
thank you, Your Honor.
And your expert will be prepared to do that tomorrow, I presume.
To discuss what he
If
reviewed?
he's asked those questions,
Yes, Your
yes.
Honor. He discussed them today. Yes, Your Honor.
Mr. Nelson, is that clear?
As clear as it can be, Your Honor.
Thank you. All right.
Thank you, Your Honor.
Anything else before we break?
Nothing from the state.
No, sir, thank you.
All right, then again, it's 4:47. We'll be in recess till tomorrow at 8:30.